Hello, everybody, and welcome to History/Law Bite number 275, dated June 14th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thanks for tuning in. This History/Law Bite is entitled Wesberry versus Sanders, 376 U.S. 1, 1964. Wesbury versus Sanders was a landmark U.S. Supreme Court decision, one of the court's malapportionment cases of the early to mid-1960s, that decided that state congressional districts for the U.S. House of Representatives had to be as equal in population as possible. Indeed, Wesbury versus Sanders was one of the most far-reaching decisions in the court's history, and forever changed the way most states drew their congressional districts for the House of Representatives. So we begin in the same way that the U.S. Supreme Court does. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. So let's get into Wesbury versus Sanders. Now, Wesbury versus Sanders, most of the malapportionment cases, began in the South, specifically in the state of Georgia. All right. So our petitioner here, Mr. James Wesbury, resided in the state of Georgia in the state's 5th congressional district, where the population was 2 to 3 times greater than the state's other congressional districts. Okay. This was a very common problem in that era, folks. So Mr. Wesbury contended that because there was only one congressman representing, his district, as is the case for all districts, his vote was, debased due to Georgia's apportionment statute and, the state's failure to realign the congressional districts. Okay? That said, Mr. Wesbury proceeded to file suit, against the governor and the secretary of state to prohibit any elections from being conducted under the statute. He's basically making the argument, that because, his district, being that it had 2 to 3 times as many people as the state's other congressional districts, and it's only represented by one congressman, just like the rest of them, of course, but the other districts have far less people, thus allowing the congressmen in those districts to more effectively represent. He's making the argument here that his vote does not count or matter as much as those in the other congressional districts in the state. Essentially, the power of his vote is substantially diluted, okay? So, he filed suit against the governor and the secretary of state from conducting elections under the statute, okay? And he initiated the suit in the U.S. District Court for the Northern District of Georgia, all right? And the decision of a 3-judge panel in that court dismissed his complaint for non-justiciability, okay, and a want of equity as raising a wholly political question. And we've talked about that in the other malapportionment cases, Baker versus Carr and Reynolds versus Sims. Okay, and non-justiciability means it is not the province for a court to decide the matter because it's a political question. Justiciability means that a court is the best venue to decide this. It's justiciable. It's a legal question, a judicial question, all right? And the district court dismissed his complaint, holding that this was a political question. This is in spite of the court's decision the prior year in Baker versus Carr in 1962, okay? So with that in mind, Mr. Wesbury appealed the decision to the Supreme Court of the United States. Notice that he didn't have to go through the Fifth Circuit. he went right to the Supreme Court. And that's because it was a special 3-judge panel of the U.S. District Court. All right. Normally, you don't go right from the District Court to the Supreme Court. You normally have to go through the U.S. Court of Appeals, which covers that particular state. But because it was a special 3-judge panel of the District Court, he was able to go right to the Supreme Court. All right. So the issue facing the justices was, quite simply, did Georgia's disparities in the size of their congressional districts violate the 14th Amendment or undermine the citizens of the full benefit of their right to vote? With one congressional district being overbloated with people and the rest of them being what you would say normally populated. Okay. And the court ruled yes. All right. It did indeed undermine the full benefit of the right to vote. Okay. In a 6-3 decision authored by Justice Hugo Black, he outlined the following points on why Georgia's law was essentially unconstitutional. First and foremost, Black held that, as in Baker versus Carr in 1962, which involved alleged malapportionment of seats in a state legislature, the district court had jurisdiction over the subject matter, and appellants had standing to sue, and they had stated a justiciable cause of action on which relief could be granted. So Black held that the district court here had messed up big time in dismissing Mr. Wesbury's complaint because, as the court had held in Baker versus Carr, this was indeed a justiciable issue, and the plaintiff, Mr. Wesbury, definitely had standing to sue. Okay? Number 2, Black held that a complaint alleging debasement of the right to vote as a result of state congressional apportionment law is not subject to dismissal for want of equity as raising a wholly political question. All right? Because allegations of debasement of the right to vote is certainly a justiciable issue, not a political question, folks. All right? Number 3, the constitutional requirement in Article 1, Section 2, that representatives be chosen by the people of the several states means that, as nearly as is practicable, one person's vote in a congressional election is to be worth as much as another's. Okay? Now, that being said, I will read some of Mr. Justice Black's opinion directly, all right? And Black wrote that this brings us to the merits of the case, okay? After Black held that the district court had erred in dismissing Mr. Wesbury's complaint, he wrote, "We agree with the district court that the 1931 Georgia apportionment grossly discriminates against voters in the 5th congressional district, all right? A single congressman represents from 2 to 3 times as many 5th district voters as are represented by each of the congressmen from the other Georgia congressional districts." Remember here, Mr. Wesbury's district had 2 to 3 times as many people as the other congressional districts in Georgia, all right? So, Black held that the apportionment statute thus contracts the value of some votes and expands that of others. That's a no-no. If the federal Constitution intends that when qualified voters elect members of Congress, each vote be given as much weight as any other vote, then this statute cannot stand. Okay? We hold that, construed in its historical context, the command of Article 1, Section 2, that representatives be chosen by the people of the several states means that, as nearly as is practicable, one man's vote in a congressional election is to be worth as much as another's. All right? Black went on to argue that All elections ought to be equal. Elections are equal when a given number of citizens in one part of the state choose as many representatives as are chosen by the same number of citizens in any other part of the state. In this manner, the proportion of the representatives and of the constituents will remain invariably the same. It is in the light of such history that we must construe Article 1, Section 2 of the Constitution, which, carrying out the ideas of Madison and those of like views, provides that representatives shall be chosen by the people of the several states, and shall be apportioned among the several states according to their respective numbers. It is not surprising that our court has held this article gives persons qualified to vote a constitutional right to vote and have their votes counted. United States versus Mosley, Ex parte Yarborough. All right? Not only can this right to vote not be denied outright, it cannot, consistently with Article 1, be destroyed by alteration of ballots. See United States versus Classic. Okay? Or diluted by stuffing of the ballot box. See United States versus Saylor. No right is more precious in a free country than that of having a voice in the election of those who make the laws under which, as good citizens, we must live. Other rights, even the most basic, are illusory if the right to vote is undermined. Our Constitution leaves no room for classification of people in a way that unnecessarily abridges this right. Okay? In urging the people to adopt the Constitution, James Madison said in Federalist 57 of the Federalist Papers, who are to be the electors of the federal representatives? He's talking about the House of Representatives, by the way. Not the rich, more than the poor. Not the learned, more than the ignorant. Not the haughty heirs of distinguished names, more than the humble sons of obscure and unpropitious fortune. The electors are to be the great body of the people of the United States. Okay? Readers surely could have fairly taken this to mean one person, one vote. Before I go any further, I want to add that that phrase that you've heard, one man, one vote, is derived from this decision, where it is written, however, as one person, one vote, Wesbury versus Sanders. Continuing, while it may not be possible to draw congressional districts with mathematical precision, that is no excuse for ignoring our Constitution's plain objective of making equal representation for equal numbers of people the fundamental goal for the House of Representatives. That is the high standard of justice and common sense which the founders set for us. And that's how Black concludes his opinion. All right? And the judgment in this case was a reversal of the district court's dismissal and a remand for proceedings consistent with this opinion. All right? Now, not everyone agreed with Justice Black. All right? Justice John Marshall Harlan II, our notable scholarly conservative of the Warren Court, filed a dissent that was joined by Justice Potter Stewart. All right? But before we get to Harlan's dissent, let's cover Justice Tom Clark's concurrence/dissent. All right? Justice Clark's concurrence/dissent emphasized that while he agreed with the majority opinion that the district court was wrong for dismissing the suit, he felt that it should have been remanded for the district court to consider whether there had been a 14th Amendment violation, as Article 1, Section 2 of the Constitution did not specifically prohibit unequal populations, all right, in congressional districts, all right. Justice Clark raises a good point. Justice Black essentially is interpreting Article 1, Section 2 very broadly giving it definition that it technically does not textually require, which is kind of ironic because Black himself was a self-professed constitutional textualist, which is what I myself am personally. So Clark agrees with the outcome, but does not feel that Black was correct in holding that Article 1, Section 2 requires equal districts because it does not specifically forbid the states from drawing congressional districts that are unequal in population. All right? So that's where he disagreed with Black's majority opinion. So let's move on to Harlan's dissent. Now, Justice Harlan's dissent, very scholarly and prolific as always, argued that Article 1, Section 4 vested exclusive control over state districting practices in Congress. All right? So the court, through its decision, was essentially overriding the Congress, which had decided not to require equally populated districts. So interesting, Harlan was always, looking to find just precisely where the majority was superimposing judicial will over the will of other branches of government or over that of the people, all right? And Harlan was never nasty, mean, or rude in his dissents. He was always very scholarly and to the point, all right? He also sarcastically asserted that, perhaps the majority might want to remake the Senate as well while they're at it, all right? But of course, as the Constitution specifically requires 2 states for every senators, that is not something that was about to happen, okay? All right, so as a result of this decision, all right, the legacy of Wesberry versus Sanders, all right, the states, almost all of them as a matter of fact, had to quickly redraw their congressional districts to comply with the Supreme Court's decision here, all right? Making all of their congressional districts substantially equal in population, as equal in population as possible, all right? Certainly, that was easier for some states than for others, all right? Undoubtedly, the smaller states probably had an easier time doing this than states like New York or Texas and Florida and, California, And as a result, each member of Congress today represents between 760 and 770,000 people each. All right? On average, when you divide 435 representatives against 330 plus million people, that's about the figure you get, which in my opinion, as I've stated in other videos, is hopelessly overbloated and, far too large for effective representation. I mean, each member of Congress is representing almost 1 million people each, folks. And as I've said from the beginning, we need a larger House of Representatives. This is not democratic, okay? Wesberry versus Sanders certainly was a move in the right direction, all right? And I completely agree with the court's decision. But what needs to happen now is an increased House of Representatives in size, all right? House of Representatives needs to be at least 1,500 members or more to provide more effective representation for the American people, all right? Because at this rate, a member of Congress cannot possibly hope to represent their constituents when their constituency base is almost 1 million people each. I mean, that's illusory for all intents and purposes. That's totally false. It's not going to happen. All right, it's a pie in the sky dream to think that citizens will be effectively represented with districts that large. Okay, it's not going to happen. Certainly, it could happen if districts had more than one representative. All right, but with one member of Congress representing each district, 770,000 people each, almost. But at any rate, enough of my ranting. that is what we have today, all right? And thus, once again, in conclusion, all right, the holding of the Supreme Court here in Wesbury versus Sanders was that state congressional districts, all right, for the U.S. House of Representatives had to be as equal in population as possible, as practicable, all right? States in drawing their congressional districts had to make their districts for the U.S. House of Representatives as equal in population as possible, as practicable, all right? So that's the holding of the court in Wesbury versus Sanders, 376 U.S. 1, 1964. All right? Any questions or controversies, leave them down below. I'll be happy to answer them. If you gained something from this video, drop me a like, especially if you learned something, which I certainly hope you did. All right? And if you have not subscribed to my YouTube channel, please do so now. It would be most graciously appreciated. All right? Take care, stay safe out there, and I will talk to you at the next bite. Peace.